The Second Amendment to the United States Constitution is part of the Bill of Rights and was ratified on December 15, 1791 also. The amendment addresses the right to keep and bear arms. Although its interpretation has been the subject of extensive legal debate, scholarly discussion, and public controversy. To give you some full text here, a well regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Back in 2021, in September, the New York Rifle and Pistol Association versus Bruen also verified that individuals can hold arms in public without permits. Give you some context there. More context. One, a well regulated militia. The amendment begins with a reference to a well regulated militia, which has been interpreted in various ways. Some argue that the amendment protects only a collective right to bear arms within the context of a militia, while others contend that it protects an individual right to bear arms for self defense and other purposes, independent or militia service. What I was just saying about the Bruen case. Two, security of a free state. This phrase emphasizes the role of armed citizens in maintaining the security and freedom of the state. It reflects the framers' distrust of standing armies and their belief in the importance of a citizen militia. Three, right of the people. The amendment asserts that the right of the people to keep and bear arms shall not be infringed. This has been the focal point of legal debates, with some interpreting it as an individual right and others as a collective right tied to a malicious service. The Bruen case again, right? Four, shall not be infringed. The language is absolute, but the right to bear arms has been subject to various forms of regulation and limitation. For example, there are laws that prohibit the possession of certain types of firearms, such as automatic weapons, and regulations that impose background checks and waiting periods for gun purchases. The Bruen case again, right? Which throughout uh, those limitations as far as having a permit or a license for it. In some legal cases, the Second Amendment has been the subject of numerous legal cases. Two landmark Supreme Court cases are particularly noteworthy. I just gave you one with the Bruen. The United States versus Miller, 1931. The District of Columbia versus Heller, 2008. And United States versus Miller in 1939. This case upheld the regulation of firearms that had no reasonable relationship to the preservation or efficiency of a well regulated militia. 2. District of Columbia versus Heller, 2008. This case ruled that the Second Amendment protects an individual's right to possess a firearm for self defense within the home, separate from a militia service. All right? I'll give you some public debating here. The Second Amendment is one of the most politically charged and controversial amendments. It is often cited in debates over gun control, with arguments ranging from the need for more stringent regulations to reduce gun violence to concerns that such regulations infringe upon individual liberties, which is true. All right. Overall, the Second Amendment continues to be a subject of intense scrutiny and interpretation, balancing the right to individual self defense against the need for public safety. In most cases, you know, they really don't want a certain group of people with those, well, being able to hold guns, and this is what the public debating is about. But the people who can't hold guns because of certain charges that they may have in the past is also now seeking to hold a gun because there's no more requirements of having a permit or a license for it. you know and in most instances, from my own opinion, I think that if everyone was to have a gun, maybe the next person to think twice about running up on somebody with a firearm knowing that they're going to be strapped too. So, that's very important, but that's just my opinion. What y'all think?